All right, good morning, ladies and gentlemen. Thank you for all being here today. I want to thank the TDLR staff for being here today and putting this thing together for us so we can sit here and enjoy the benefits of their labor. So thank you, TDLR staff and everybody for being here today. So I'm going to bring the meeting to order. Just a little housekeeping rules. Please say your full name before you speak. This meeting is being televised and broadcast. So if you would, there we go. If you would just please do that for us, so the viewing public can know who's talking and what the topic and who you are. So thank you for that. So let's go to roll. Mr. Richard Anderson. Here. Mr. Jerry Brenner.
Here.
Now, Mr. Jerry Brenner is a new member to the board. We welcome him aboard and thank you for helping us.
Thank you.
Welcome aboard. Dolores Campion here. Mr. Pat Kiley, I'm sorry. Mr. David Morris. Mr. David Yelovich. All right, so now we don't have a quorum today. So there'll be a few agenda items that we will have to move to the next meeting. One of them being item C, the approval of the minutes, and item I. So with that said, we're going to move to any public comments. So this is going to be a short meeting. There were some items that we moved off the table, so it was already short to begin with. So let's move on to staff reports.
Mr. Chairman and members, I'm Nick Foenis of TDLR, and I'm here to give you the executive staff report. As you know, the last time we met, we were in the throes of the 85th session of the Texas legislature. The State House and Senate convened in early January and met through Memorial Day. They are now in a special session here in town. This past regular session, more than 6,500 total bills were filed, and Delia passed out a summary of some legislative activity there for you to look at there. But of the 6,500 total bills that were filed, TDLR staff monitored 341, and that includes 130 that were directly related to current TDLR programs, 20 that dealt with new or transfer programs, and 191 bills that, if enacted, would have affected the operation of the agency. I got on board in mid-December, and right before the holidays, right before the session started, but it was very, very interesting and fun to watch the teamwork that everyone here put in towards this session. It was very important to us and to all of our programs. Every division had a hand in it and did their best to help analyze, monitor bills, and provide feedback and resource testimony. TDLR staff attended 65 committee hearings, and that was before 20 different House and Senate committees. But there was one bill during the past session that affected this program, and want to summarize it just very briefly. We'll give you more details when the folks that present item F on the agenda later in this meeting. But House Bill 3029 by Representative John Frullo and Senator John Whitmire amends the current law relating to education and certification of air conditioning and refrigeration technicians. In summary, HB 3029 allows an applicant to become a certified technician through two different pathways. An applicant may complete a 2,000-hour certification training program approved by the department or complete 24 months of air conditioning and refrigeration related work under the supervision of a licensed air conditioning and refrigeration contractor. Applicants using either path must also pass a competency examination approved by the department. And the new requirements for technician certification apply only to persons applying for certification on or after September 1 of 2018. Certifications issued by TDLR before September 1, 2018 or pursuant to an application filed before that date will continue to be valid, and the previous law will remain in effect for purposes of that certification. The bill passed both houses, and the governor signed the bill on June 15th. It takes effect September 1. There's also in your packet a timeline for our bill implementation on House Bill 3029, and you'll find that there. Again, it's a team effort around the agency as everybody is working hard to develop rules, communicate to stakeholders, prep new advisory boards, hire additional staff, and deal with education exams, IT programs, and other things. To see a full review of our legislative program, simply go to our website at tdlr.texas.gov, click on the picture of the Capitol there, and it'll take you to a page that will break down each bill by program. Also wanted to just take a minute to encourage you, if you're on social media, to join us on Facebook and Twitter to keep up with TDLR events and news. And that is about it, Mr. Chairman, and I'd be glad to answer any questions for you.
Board, any questions? Thank you so much, sir. Appreciate it. So move on to short meeting. F. Mr. Lane?
Good morning, gentlemen. John Lane, Compliance Division. Folks around here in this regard know me to be brief, and I'll maintain that tradition, especially with what Nick just told you. That pretty much summarizes what I intended to speak on agenda item F, so I will come back up at your pleasure, and maybe we can fill in a few details. If I'm not able, I'm sure Shannon and Todd can keep me straight. Thank you, gentlemen, for being here. You have in your packet my report, and it just summarizes since our March 8th meeting, some of the places I've been, certainly not all. Mr. Anderson, we participated with your group in Beaumont back in June. Good turnout. Always enjoy those folks and the opportunity to impart law and rule on behalf of the agency and the AC program. The one thing I want to point out to you gentlemen relates to this agency's core values and specifically teamwork. This is an ongoing effort by all staff, but there's a relationship that exists between myself and the Enforcement Division staff that is exceptional, and it was exhibited last Tuesday when Enforcement Investigator Robert Nino and myself traveled to Big Spring. There was a case there that required us to inspect. In the process of that meeting with those folks, we facilitated an informal resolution that resulted in that homeowner writing a withdrawal letter to the department. These are some of the things that occur with compliance staff, enforcement staff, and I'm continually encouraged by the folks that we have in that division that allow me to work with them as a compliance subject matter expert. Just wanted you folks to know that. If there's any questions of my report or any other questions for me at the time, try to entertain an answer. Otherwise, that concludes my Compliance Division report.
Thank you, Mr. Lane. Good morning.
Good morning, board members. My name is Lorraine Srove. I'm with the Education and Examination Division. You should have before you our report as well. It contains the exam statistics and the CE statistics, which if you'll notice have remained consistent. There's no major changes there. And our staff does have 2 members on the implementation team of House Bill 3029 as well. Since we just met in March, there really has not been any changes within the division. So I'll let you just look over those statistics, and if you have any questions, I'll be glad to answer them. Otherwise, that concludes my report as well.
Any questions, gentlemen?
No.
No.
Thank
Thank you
you.
so much.
Good morning, gentlemen. My name is Trevor Thielen, and I'm glad to have the opportunity to present to you today on behalf of the Enforcement Division and bring you up to date on some of the things that have been happening since the March meeting. As you can see from your the prepared notes, we'll start with what some of our investigators have been doing out in the field to help educate industry members about the department, about how we implement our policies, the laws, the rules, etc. Since March, we've had investigators appear at 2 meetings of the Texas Air Conditioning Contractors of America in Houston, and we've also had another different investigator go to 2 meetings of the Refrigeration Service Engineer Society meetings in San Antonio. These are things that we are constantly doing to try to bring everybody up to speed on what we are doing, make sure there's a face out there that people feel comfortable talking to in the industry. We get cases from those contacts, or we get information. Sometimes we build contacts that help out the advisory board or the commission in doing their work. And so that's all part of the outreach that enforcement tries to do. But as far as the actual cases that we spend the bulk of our time working on, since the last meeting, we have conducted a sting in the Rio Grande Valley. This is the second sting we've done in that general area in the last 2 years, after we had a longer time where we were focusing on more of the major metropolitan areas, Houston, Dallas, Austin, San Antonio. We're trying to reach other places as well, and so this is doubling back to down in the valley, because there is a lot of unlicensed activity that goes on down there that we get complaints about, and it can be really hard to prove those cases. We do the stings to produce cases that are stronger. They have stronger evidence. We have investigators go down there. They set up in a sting house, usually a unused property that's given to us for use by other industry professionals who also have a concern about the unlicensed competition that they're facing every day. Our investigators will pose as homeowners or business owners and develop a list of sting contacts, leads for the cases. They will call these in a very organized and recorded manner and tell them, hey, we've got air conditioning work we need done out here. We have electrical work that we need done out here. The same prosecutors that work on the electrical cases also work on the AC cases, so it's beneficial to work stings and hit both of those programs. Invite the person out. We try to get video or photos not only of the person but of the vehicle. We try to get business cards, any advertisements that they're handing out. We try to get them to give us an invoice for any work that they're going to offer. We also try to specifically nail them down on who's going to be doing the work, because a lot of times the go-to excuse is, well, I was just there generating leads for this other guy and he's licensed, and maybe that's true. Maybe they have a friend who's licensed after the fact and they're trying to cover themselves. We try to eliminate a lot of the common defenses that people use in these types of cases and build strong cases. At the same time, we work with local news media to cover these stings, kind of like a to catch a predator type of media experience that they can put a special report together on at the end, and that's when we are doing the second part of what I think makes our stings so effective, communicating to the public that, hey, there's a danger from unlicensed air conditioning people in your area. Here's video of them offering. Here's them getting caught. It's very entertaining, compelling news reports that get shared online, watched in local broadcasts, and we hope educate the public about what dangers there might be out there, educate them that TDLR exists and the ways that they can verify that people are licensed, and hopefully protect themselves, because them doing that on the front end makes, I think, the biggest difference in eliminating the danger and the unfair competition posed by unlicensed contractors. So we had a sting down in the Rio Grande Valley. We had that media coverage on the local CBS affiliate, and those cases generated air conditioning and refrigeration and electrical cases. Those cases are going to be split among 2 different prosecutors, so they should be able to handle them very efficiently. We've done more stings, but this is just focused on what's happened since the March meeting. We usually try to do, I think, 2, 3, 4 a year. Moving on to the highlighted cases, where I've broken down some details of cases that we had. First, I just want to let you know, disregard the details on the second case. There was some inaccuracies that I put in there by mistake, and not all of that information is reliable. But the other 4 are. I'm going to highlight 3 of them. The first case involving a Mr. Michael Dillingham. This type of case is not one that we generally present to the advisory board during one of these presentations. But I thought when I was asked to pick some cases that it would be important to highlight to you that it's not just unlicensed cases and air conditioning contractors violating the rules that we go after in enforcement. We have 2 prosecutors, Bob Rennick and Ken Sharp, and their almost overwhelming majority of their job is to handle what we call criminal history cases. This case with Mr. Dillingham is a good example. He tried to renew his license, his air conditioning and refrigeration contractor license, in 2015. And on his application, there's a part where it asks, have you been convicted of or placed on deferred adjudication for a felony or other types of crimes since the last time you made an application? He checked no on that. Unfortunately, he had been convicted of a felony. It was a theft by a public servant, and we flagged that because we do a Department of Public Safety criminal history search every time that we're getting one of the initial applications or renewal applications. And theft by a public servant not only was a crime that indicates that he may not fit the trustworthiness, it's related to the profession. We've got to have trustworthy contractors out there because they're dealing personally with people who may be falling victim to untrustworthy folks. And also, another basis for why we've generated a case was the fact that he lied on that application. So Mr. Rennick sought to revoke Mr. Dillingham's license that he renewed in 2015. When that happens, we send him a letter proposing that, hey, we're going to take this action. In this case, it was the revocation of the license. If you oppose that, you can ask for a hearing before a SOA judge. A lot of cases, they don't do that. In this one, Mr. Dillingham did ask for a hearing. The case went to SOA. Mr. Dillingham was given the opportunity to present his side of everything, and Mr. Bob Rennick, one of those prosecutors I mentioned, and I want to add that at the end of August, he's actually going to be retiring. So he's been here for a very long time, and we're really proud of the work that he's done in shepherding these types of cases. He argued that the license should be revoked. The SOA judge, unfortunately, disagreed with him and instituted a 3-year probation of Mr. Dillingham's license instead. At least that's what the judge recommended. But as we know, our SOA judges aren't the final word in any of the cases that we bring towards them. The commission is. And like all the rest of the cases, Mr. Rennick sat up here, he presented to the commission that he thought that the SOA judge was off base in their recommendation of the probation, and the commission agreed with him and went ahead and revoked Mr. Dillingham's license. They revoked it at their March 2017 meeting, and that means that Dillingham won't be eligible to reapply for that ACR contractor license until March of 2018. And he will have to apply as if he were applying for the first time at that time if he wants to continue in the profession. Skipping down to some more standard types of cases that we handle, I'll just quickly hit on David Rodriguez. This was what we call a mechanical integrity kind of case. Mr. Rodriguez violated the National Electrical Code. He also failed to install a sediment trap into a fuel gas piping apparatus. Our newest prosecutor on the team, Dawn Burton, handled this case, and she was seeking $2,400 penalty and revocation of Mr. Rodriguez's license. Mr. Rodriguez came to the table and decided, you know, I need to settle this case. Can I get a better deal than that? And so we offered him a standard half of the penalty he would have faced if he took it all the way to a hearing. So he ended up agreeing to a $1,200 penalty. And instead of having a license revocation, he got a license suspension for a limited amount of time. He's on monthly payments for that $1,200, and he seems to be on track towards making that payment over the course of the suspension. And then finally, at the bottom, we have a case involving Bob Hunter. This case was an unlicensed case, and that is, I would say, at least half of our cases that we handle are unlicensed cases. They're a little simpler in terms of their facts, but we take them very seriously, and we seek significant penalties in them. Mr. Hunter installed new ductwork and added refrigerant to a dehumidifier system for a hotel indoor pool area and got caught. Mr. Medlock sought a $4,000 penalty. That's the standard amount we seek in a case where we can prove someone's performing unlicensed air conditioning and refrigeration. And Mr. Hunter settled that case for $3,000, paid it in full. That case is done. Moving on finally to the statistics. If you consider what percentage of just the air conditioning numbers are out of the TDLR whole, in terms of number of cases opened and resolved, you get about 8.5%. So what does that say? That means that basically about 8% of TDLR's enforcement division work is devoted to the air conditioning program. When you consider we have over 30 programs and we're getting more all the time, I think that represents a significant amount of enforcement activity and the emphasis that we place on the air conditioning program and trying to make sure that it runs smoothly in Texas. As far as the number of agreed orders, you'll notice that the percentage goes down. It's only 5.8% of the overall number of agreed orders that we have throughout the agency. The reason for that is we resolve cases in a number of different ways, not necessarily involving agreed orders. We have default orders, and those come into play a lot in the air conditioning program because we have so many unlicensed cases. A lot of the folks who are unlicensed, it's no surprise when they don't request a hearing or even respond to the notices we're sending them. The penalties still get imposed, but those cases aren't agreed to. And that is why in the next statistic, when we see the number of penalties assessed, that number jumps to 17.6% of all the penalties assessed by TDLR. When you commit unlicensed contracting and you don't settle your case, you're going to face higher penalties. You're going to have repeat penalties. And so that is why I think the ACR program has a higher amount of penalties assessed out there. The total amount of penalties collected is necessarily a much lower number, both for TDLR and for the air conditioning program. But it's about 7.5% if I calculated that right. So that's pretty close to the first couple statistics, about the 8% in terms of numbers of cases opened and resolved. Finally, I just wanted to highlight two things. At our next meeting, we are going to be asking the work group to do something that we originally thought we were going to be able to get to today. I think it was item H on the agenda, which is to ask for a work group to be assigned to consider potential changes to the enforcement plan. There's a few things we're trying to achieve with that. Our enforcement plan, if you don't know, is sort of the guidebook for the prosecutors and for the public in what types of penalties to expect when certain violations are committed. And we're going to be recommending that we make some changes to the enforcement plan based off of changes to the law. Some violations are no longer violations, or they've moved around, changes to the rules. And also, I think the bigger thing is we are in enforcement trying to implement some of the strategic goals that TDLR set to target our enforcement resources, recognize we have limited resources for enforcement, and make sure we're targeting the most important cases, the cases involving harm to the public, whether that be unlicensed activity or from unscrupulous licensed folks. And we're also trying to make the enforcement plan simpler, easier to follow, easier to use, and we're going to be hoping for your help in doing that. The second thing I just wanted to highlight, we get a lot of these statistics, we get the same statistics every time. They don't really highlight everything that we do. One of the things, a few of the things that they miss was highlighted by Mr. Lane earlier. When I resolve a case, I might be imposing a penalty, but I might also be recognizing that that contractor recognized that they maybe made a mistake, and they went to the customer and they tried to make it right with them. And a lot of times that results in that customer, that complainant, withdrawing their complaint, or making some sort of arrangement for reimbursement, or makes arrangements for somebody else that the customer trusts to come out and do the work, or maybe the customer trusts them enough to give them a second shot at doing the work. We try to encourage those types of resolutions because we don't have the power to be the civil court system and help those complainants, those customers get their money back or be made whole. And we try to reward the contractors who do that. So we close a lot of cases where the contractor comes to the table and says, let's make this right, let's find a way to make this right. And if it's appropriate, we'll sometimes close those cases. We also, as prosecutors, don't accept every single case that comes to us. We take a hard, close look at the evidence that we have, at what sources of that evidence there are, and whether or not that specific evidence, while it may be indication of some sort of wrongdoing in the larger sense, does it apply to the specific laws and rules that TDLR has in its toolkit? And if it doesn't, then we have to close those cases for insufficient evidence. We have to implement the law fairly and uniformly. And I just wanted to highlight that that part I feel like is harder to represent in the statistics in the presentation. We're trying to strike the balance and do what all prosecutors are supposed to do, which is seek justice in every case, whatever that may be. Are there any questions that I can answer?
Yeah, Dolores Compion, I do have one question on the first highlighted case. If Mr. Dillingham would have been a little bit more forthcoming at the very beginning with the case taking a different path.
It very well could have. I don't personally work on these cases, and I can't speak for Bob Rennick in exactly what his decision-making would have been. But I think that it is always better for a contractor or any type of licensed applicant who has some sort of criminal thing to disclose it, because it is far easier to look at that person's they not only get to disclose what they have to disclose what they did, but they also get an opportunity to explain what happened. And sometimes the facts just don't merit taking away somebody's license, or they merit a lesser or alternative response from us. If we took out the lying on the application from the overall consideration, I don't know what the result would have been specifically in this case, but many cases it does totally change how TDLR is going to approach that application. And when people are honest with us, that's a great first step in giving us the room to hopefully give that person leeway if that's appropriate for those cases.
Any question, Jim?
I had a question on your statistics,
Okay?
and you threw some numbers out that we don't have the percentages, but for a number of cases resolved, you kind of broke that down into a couple of different categories, correct?
Yes. That
So
would,
would there be a benefit to actually publishing those categories? Do you have the capability of breaking those down into the ones that got closed, you know, 'cause
We
you guys
do.
came to an understanding, or what? Would we see a benefit in doing that at all, and providing that?
I think, sure, that could definitely be of benefit. We keep records internally of which cases are closed for insufficient evidence, complaint withdrawn, informally resolved, unable to locate. That's a very small number of them, but sometimes we can't physically serve somebody. We have to close cases for that. Agreed orders, default orders, commission orders. So yeah, we keep breakdowns of those facts, and I'm sure we could provide those statistics either in the future or maybe in an update afterwards. And Chris Rusty's giving me a thumbs up that that does seem to be something we can do. So we'll definitely try to get back with you on that.
Thank you.
With regard to the Rodriguez example, do we happen to know what the electrical code violation was?
I don't. I can find that out and let you know.
That would be helpful, since we typically do very little electrical work under our guidelines.
Absolutely.
One more follow-up question. You said on case 2 there were some discrepancies. Are you going to provide us with the corrections to that?
I can, absolutely.
Thank you, sir.
Thank you.
Good morning, board members. Welcome new members. I'm Lisa Hodag, the licensing manager. And my report shows fiscal year 15-16 and third quarter of fiscal year 2017, which goes through May. And this is, my report is usually shown like this. It has the new licenses issued, renewed licenses issued, as well as our online population and percentage, which is always high, and then the total population for each license type. Currently, our total population for all of our licenses is 44,525, and again, that's through the third quarter, which is ending in May. And I would also like to add that I am a member of House Bill 3029 implementation team. And what that means is we'll be working on frequently asked questions, forms, that type thing. And of course, Mr. Lane will be going over that further in detail. And that concludes my report. I'll be happy to answer any questions that you may have.
Members, any questions?
No.
Thank you so much.
Thank you.
Moving on to Agenda F. Do we need to cover Agenda F again? I think we've kind of covered that already.
Yes, sir.
Unless you want to expound on that, John.
I can.
John Lane, again, compliance. Well, I wasn't paying attention. We're moving fast. I didn't think we were at F yet. Thank you, Nick, for your summary on House Bill 3029. It allows me the opportunity just to fill in a few holes, maybe some questions. Staff had presented to you gentlemen a copy of the bill, right? And you've got a copy of TDLR's implementation timeline that we hope to have that be a guideline for us as to when we can present And I think with that said, what's most important to us is that April 1 deadline to have the commission adopt those rules. So David Gonzalez and I, my supervisor, we were talking this morning and backing up, and it looks like as the team lead, I need to send some communication to those team members as to rules need to be thought about. I understand possibly that we'll have an October meeting, so we hope at that point to be able to have rules for this board to weigh in on. I wanted to just outline a couple of things for you gentlemen's benefit and for all of the listeners. This is a voluntary program, and I think that word carries the significance that we all want to understand with this bill. And if I could take you back 10 years ago, that legislative session and governor gave to this agency the technician registration law. And all of us would remember that basically it was a criminal background, and it said simply that those assisted a licensee in the performance of maintenance work needed to be registered with the department. You heard Mr. Thielen reference the Department of Public Safety, where we would let that criminal background effort occur. The language of that bill 10 years ago didn't provide the guidelines that were necessary. It called out for those folks that wanted to be a certified technician, that if they could produce documentation from a nationally recognized qualifying organization. That program ballooned on us, and it sort of got out of hand as to, because there weren't those clear guidelines, entities that presented to the agency that wanted to be considered as a qualifying organization. So I think for me, as I sit here as your compliance subject matter expert on the statute, House Bill 3029 does a significant thing for us. It clearly establishes what those guidelines will be. You heard Mr. Baronis tell us, as he outlined those dates, there were those paths. And now we have, through the language of that bill that identifies what a certified training organization is, and it's spelled out in the Texas Education Code, what they refer to in their definitions as 61003. It's a very narrow description, and I would call your attention to, for familiarity, the Lamar Institute of Technology is an entity. TSTC, Texas State Technical College, certainly is going to qualify according to those parameters. And I would say to you that the language spells it out clear enough that all junior colleges that have an HVACR program that would, what we think of as a 2-year associate's degree in applied science in air conditioning, refrigeration, those entities are going to qualify. Certainly our regard and respect for those that have served in the military. If they had a military occupation specialty that was air conditioning and refrigeration, and they had performed in that capacity for 24 months, they're qualified by the language of that law. There are components, and Lisa, thank you, Lisa Hodek from licensing. I had guessed that there were approximately 5,600 certified technicians that you heard Mr. Varonis talk about that would be grandfathered. I see on her report that number is 5539 as we speak. Standard requirements for this mean that you've got to be age 18. There's a component that interests me, and I expect that it'll cause me to have some additional travel, which I welcome. Those high schools around the state that have an HVACR vocational tech program, they're going to qualify. Now, of course, the department will have staff that will review those documents and vet the certification protocol. But on the surface, we read that law to say that those individuals, gentlemen, what this is all about is we need more tradesmen. We need better qualified and better trained tradesmen. And this law, this bill, I think is the right step in that direction. Ms. Hodek spoke about the bill implementation team. Time gets away from us, and I guess I've served on 4 or 5 now in the last 10 years. The executive office has honored me with being that team lead, and they've also placed some exceptional people on that team, and there are other consultants that represent all divisions. We've already met, and we have a technology that we're using that is a SharePoint where we can, if you will, it will be our repository. And instead of us having to have a lot of meetings, we can communicate electronically, and then we can go to that SharePoint location and add, edit, amend things like you've heard this morning, FAQs, certainly forms with maybe some necessary revisions. But the number one item for us is to get some rules before you that we can then present through our general counsel's office to the commission. You guys will remember that we've got to go through that process with the Texas Register and the 30-day public comment period. So that backs us up from that calendar if you want to as you go forward reviewing those timelines. The program is going to require an examination. It'll be a TDLR examination. My expectation it'll be similar to what we're familiar with the air conditioning contractor license and how that's formatted. That's got to be fleshed out yet by staff and then by this board and certainly the public and the commission. What I would want to wrap this up for you, and you have that bill, is to focus for you on those requirements that I think are important. Anyone that wants to advance their air conditioning career through one of these paths has to present with verified 24-month experience. And as you've heard briefly and you'll read in the law, there's a component there where that can be a combination of classroom instruction, which is outlined clearly to be 2,000 hours, which I think all of us would agree is 1 year. So if we look at this program, we see that it's a 2-year program. And you can advance down that path with 2 years under the supervision of a licensee, or that combination of supervision under the licensee and an education program as defined by the education code. We talked about the military. We talked about the students in the public school program. It has a sweet spot in it. I applaud those authors and the ones that generated this, and that would be the Texas Air Conditioning Contractors of America Association. They recognized the issue as all of us see it, and the sweetener is currently we require 48 months of experience verified under the supervision of a licensee. If you elect, if you're so inclined to pursue your career and have that desire of wanting to be an air conditioning contractor, you can do that in 3 years. You'll do that 2-year as described, outlined in the law. You will possess that new certified technician license, if you will, for our industry, a journeyman. You continue under the supervision of a licensee 1 additional year, you're eligible to sit for the Texas Air Conditioning Contractor license. So to me, that's a great incentive if there are those that aspire to advance their career. Lastly, there's a continuing education component of this. So we'll be working out those details. I think it'll be something that is similar to what y'all are generally accustomed to. Continuing education is our future. It's been our future for a long time in this industry and many others. So changing technology necessitates continuing ed, and we'll have that as a part for you. Hope you'll look at your bill and get smarter than me about it. And if you have questions, I would hope that you would either email or reach out to me. But I'm excited to be that team lead. We've got a great group, and I expect that we'll meet our deadline. We'll probably be a little early.
Dolores Compion, look, John, I appreciate all the efforts from all the team members. I know this has been a long time coming to build a career path for our young men and women who want to join the industry. So look forward to it. Thank you.
Thank you.
Thank you, John.
Thank you, Delia.
Move on to Agenda G.
Good morning, gentlemen. Doug Jennings, Assistant General Counsel for the department. In your materials, you'll see a proposed rule 75.110, applicable codes. And I'll just refresh your memory a little bit about the process that we go through in rulemaking. This body, the advisory board, 2 meetings ago, I believe, recommended appointment of a work group to explore whether the applicable codes for the ACR program should be updated from the 2012 versions to the 2015 versions. That work group met and disclosed its findings to the board at the next meeting and recommended publication of the rule that you see before you. And what the rule does, it updates the Uniform Mechanical Code, International Mechanical Code, International Residential Code, and other applicable codes from the 2012 versions to the 2015 versions, and that becomes effective on January 1 of 2018. So the previous, the 2012 codes will be applicable till the end of 2017, at which point at the beginning of 2018, the 2015 codes take over. So this rule proposal was published in mid-June, and the public comment period just closed 7 or 8 days ago, yes, on July 17th. We received one comment, and it was from Mr. Gary Hulsey, who just expressed his support for the code update. That was the only comment we received. We're in a little bit of an odd situation this morning, not having a quorum with the board. Typically what we like to do is once a proposed rule has been published and we've received comments, I like to come to you with the comments and then ask for your formal recommendation to pass the rule along to the commission for adoption. We can't really take that formal action today. And so I spoke with the chair earlier today, and my game plan, we would like to have this rule in the books. We would like to have it appear in the administrative code well before January 1. And so in order to facilitate that, I would like to present this rule to the commission for their August meeting and have it approved at that point. If the commission adopts the rule as proposed, we would then file the rule, and 20 days thereafter, the code would be, the rules would be updated. Once again, keeping in mind that this rule would appear in the administrative code, but once again, the updated codes wouldn't actually take effect until January 1. So I just want to be clear about that. So I cannot ask for your formal recommendation to pass along this rule to the commission for approval, but what I can do is, if you don't mind, kind of take the temperature of the 3 members we have today and see if there are any questions or objections or concerns that you might have that would maybe that would change my mind or change the exec's mind on whether or not to present this rule to the commission for their approval. And so I would just ask you if you have any concerns or anything like that. We've got compliance staff on hand to answer any technical questions. I'm here for questions of a legal nature. So,
Dolores Compton, no comments. I was part of the original work group that we committed to and advising to make those changes. So for me, it's a go. No negative comments at all.
For me, with staying on the most current code adopted is a benefit to those we serve, our citizens, our contractors. Technology is constantly moving forward, and new products, new materials, new methodologies, and if we're not under the most current code, I feel that we're not doing the best thing for those we serve.
thank you.
Mary Winston, TDLR. Mr. Anderson, thank you. I just wanted to put your name out there for our YouTube watchers.
Yes.
Who can't read the nameplate. So just make sure we introduce ourselves before we make our statements.
Sorry about that. Richard Anderson.
Thank you.
On the tail end.
And let me just explain to you once again with the process that I will go through. Since once again we don't have formal action today to approve this, to present the rules to the commission, I will work with General Counsel and with Exec, and we will determine whether or not to take this rule to the commission. There's some possibility, if, for example, if Mr. Francis decides that we need to reschedule another meeting of this board to get your formal approval, we'll do so. But preliminarily, my thought is that we might just go ahead and present this to the commission, since it doesn't appear that there are any objections, and that this rule itself is a recommendation, arose from a recommendation from this body, so. But we'll keep you posted either way that goes, obviously.
The Lord's comment, no objection here. Thank you so much.
All right, thank you.
Moving on to, lost my place here for a little bit. H, so we're gonna table that to the next meeting. No, we're not able to create a work group because of we don't have a quorum. So with that said, we're gonna move on to, I as well, which is, the discussion of the work group, just to be clear, on the work group findings, the possible recommendations for whether persons performing manual J load calculation should be required to hold an ARC license. So we're going to table that to the next meeting as well. Because of the lack of the quorum and of the work group, me being the only member of that work group here today. So with that said, we're going to move on to closing out the meeting. We're going to move on to J, recommendations for agenda items for our next board meeting. At this particular time, I don't have any agenda items. So lastly, date and time for our next meeting?
Well, Mary Winston again, I think that the items that we passed on, we would like to
Move to the
definitely
next.
set those at the next meeting. If we, and that is actually quite a bit of discussion that will have to go on, but we definitely want more of the board to be here to participate. If you have anything else, or if any of our board members, presiding officer, Campion, have anything before our next meeting, please contact advisory.boards@tdlr.texas.gov, or Mr. Lane or David Gonzalez. Get word to us what you want on the agenda so that we can put it on there before the next meeting. But definitely the two items that we passed, 2 or 3, that we had to pass on because of our lack of quorum. And the minutes also, since we passed on those, we will take those minutes up at that time.
So we're moving a C
Yes.
for the next meeting, C.
Yes.
And H and I?
Yes.
All right. Next date and time? Thought it was October 25th.
Y'all are set for October 25th.
And lastly but not least, agenda L for adjournment. Do I get to say this? Do I get a motion to adjourn the meeting? So look, thank you all for being here today. I know it was kind of a very short meeting, and so hopefully next time we'll have a full board so we can have plenty of discussion around what impacts our industry, what helps our licensees, and the general safety of the public that we serve. So with that said, I call this meeting to an end, and I get to use this, right?
Get to gavel us out.
There you go.
Thank you.